Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
And tonight on the ABC News, OJ Simpson kills one more person. Oh my god, I can't believe it. OJ kills another person? I didn't know Minute Maid orange juice could kill people. I guess what happened here was that someone poisoned the OJ and, killed somebody. Thank you so much, and I'll see you next time on ABC, the horrible news in the whole world. Thank you. Well, I hope you liked how I did my commercials. I'm gonna be a star. I've always been a star, I just have to go to Hollywood, and then I'll just, everybody would be like going, oh, I want your autograph, oh, I want your autograph. But anyways, see you later. Adios. Ciao.
Hey, everybody. Good morning, good afternoon, good evening. How are you? I'm just glad whoever you are, whoever you are, whatever you're doing and however good it feels, et cetera, you're doing here with me, Legal Vices. It is time once again, as we've taken a several week break, about a month, I guess, off of our OJ streams. We had the Hannah Gutierrez trial. Then we've been wrapped up in the Hale stuff for the past couple of weeks. It's time to get back a little bit on schedule. We're still going to be covering the Hale stuff as much as we possibly can because it is so absurd and insanely weird. But we do have to get back to a little sense of normalcy. In the next week or two, we'll be getting Maritime Mondays back in gear. So it's OJ. This is episode 63. This is episode 11, I think, or 12 of the closing arguments. Closing arguments part 11. We have today and next week, and then we should be done. Next week should be the last OJ trial. One more week of Ari Jacob makes me sad. We'll miss Ari. Ari is influencer Ari Jacob, who did this introduction when she was 9 years old. Now she's super popular influencer. She's the influencer's influencer. and interesting, we're going to be talking about her again in just a quick second. But after we finish OJ next week, I hope, after we finish OJ next week, we're going to start on the case of Florida v. Hartung. It's from 2020. A 63-year-old Donald Wayne Hartung was accused of murdering his mother and his two younger half-brothers in Pensacola, Florida. They all lived together. Now, on July 28th, 2015, the bodies of these people, his mother was 77, his brother was 47, and his other brother was 49, but he's 63. So do the math. His mother is 14 years older than him. Wasn't that a scandal 65, 66 years ago? Yeeps. So yeah. But not only did he murder all three of them, they found the bodies like 3 days later. They were buried under a pile of clothes. And the police believe that it was a witchcraft ritual killing. So stay tuned for that case. That'll be starting hopefully in 2 weeks. But until then, we still got to get through, about 4 more hours of Marcia Clark. We got 4 more hours of Marcia Clark. If we've put up with Marcia Clark enough in the last year and a half or so that we can power through with just a few more Marcia Clark hours. So without further ado, let's look at our like and subscribe poll. We've got 93 people here. This is already one of our most watched OJ trials. And if you're one of the new members, we've picked up about 5,000 new members in the past couple of weeks. So if you're one of the new members and you're checking this out, wondering what the heck's going on, this is something we do every Thursday. It's a chill stream where I get to spend more time paying attention to the chat. We get to have a little bit back and forth. It's kind of an MST3K kind of deal where we just sort of joke and snark about what's going on, but we also pay attention and we learn from some of the masters of the craft of lawyering. It's just a chill stream. We just sit back and we enjoy. So please don't unsubscribe when you go, oh my God, what is this crap? just sit back and enjoy the ride, enjoy the hangout with chat. And tomorrow is also a very special day. It's our March F It Friday, where we just kind of say, F it, and we just have a giant panel of guests on. We grift for as much money as I can possibly get from you in one day of the month so that I don't really have to grift for it the rest of the month. But please feel free to continue giving super chats throughout the rest of the month. But just saying, this is the one day we designate as the Boozy Griftathon Day, where every $100 that comes in, I do a shot. And we see how liquored up I can get on your dime. It's all fun and games. We have a great panel of guests that join, and we have some great conversations. But this is very special for 2 reasons. One, it's St. Patrick's Day. And how do you have a St. Patrick's Day weekend without a Grifty Boozathon? You just can't. It's impossible. And for that, we've set aside 2 whiskeys that we're going to be drinking on our Boozy Griftathon, which is a Bushmills 10-year and a Redbreast 12-year Irish whiskey, which is some of the best whiskey you will ever taste in your life. And it's our 69,000 subscriber celebration, even though we'll probably be around 72,000 by then. We're still calling it the 69 party because we're still gonna get drunk and have a giant 69 party. Who's gonna be joining us for the 69,000 subscriber extravaganza? Here's the guest list so far: Danny on Direct, Steph the Alter Nerd, LawTube Sean, potentially criminal, Lauren De Laguna, influencer, Anna, that Star Wars girl, Nicholas Starro, Nick's one of our law tubies, and comedian Lila Hart, Ian Runkle from Runkle of the Bailey will pop in for a bit. Our very own Flux, House of Flux, will be here. Aussie Overlord Hayden will pop in. Waifu Kron Jess is the old name. The new name is Moxie Dame. Jess will be here. Talk with Sally, Lady Law 5791, MG Law, and many, many more. And as people filter out, then we'll send out another round of invites. We'll get people involved, and I will hold out. It's a race to see what happens first. You run out of money first, or my liver quits. I've come extremely close to tapping out twice. But let's see what happens on our Boozy Griftathon St. Patrick's Day 69 party. That's about 36 hours from now. We'll do it Friday evening, 8 p.m. Eastern. Oh, 9 p.m. Eastern, I said. Huh. Why did I say 9 p.m. Eastern? I don't know. I'll have to change that time. It should be 8 p.m. Eastern. All right. That's good to know. I put the wrong time up. Anyway, that's it. That's all of that. Now that I've kind of walked y'all through what's going to be happening, then we'll pick up with Hales. We'll watch part 2 of hearing 4 or part 1 of hearing. I'm confused. I don't even know what I'm going to be doing on Monday. Let me think. Part 1 of hearing number 4. That's what we're going to be doing with the Hales, the Hales incident with the tortoise queen and the turtle purgatory and everything else. But in the meantime, right now, what I want you to do is hit that like button. And if you haven't subscribed and you just happen to stumble across this weird stream we do every Thursday, stick around, hit that subscribe button. And as always, if you have subscribed, just double check to make sure you're still subscribed, because sometimes YouTube just gets unilateral and deletes stuff. And then take our like and subscribe poll. Again, it's been a month since we've done OJ, so OJ's back, baby. What's your answer? Sarcastically, yay. And yay. And yes, get me that sweet Marcia Clark. And I'll miss Donald Sutherland. If you're new here and wondering what Donald Sutherland has to do with anything, just take me seriously when I give you an earphone warning. That's all we're going to give you. And we'll check back in an hour or so and see how the poll is going. Before we get straight into it, it is Adara the Wholesome. Today's my birthday. That's right. I was born the day Mark Furman was outed as a genocidal racist. Hooray. Oh, hey, that was today. You were also born on Pi Day. It's 3.14 today. Yay, it's Pi Day. I didn't have any pie. I should have some pie, but I don't have any pie, because I'm trying to get less fat. But birthday for Adara. I'm not going to do a big shot of super peated, Port Charlotte heavily peated whiskey, because that would kill me. You just can't do big shots of peated whiskey. So we'll do a little bit of a taste for you. Adara the Wholesome, you have been a member for 5 months, but you've been a supporter for much longer than that, and I appreciate it. May you have a wonderful festive year, despite being born the day that Mark Furman was outed as a genocidal racist. Cheers for not being a genocidal racist yourself. Yeah, okay. All right. Now, once I can breathe again, that is heavily peated whiskey from Bruichladdich, my favorite distillery in Scotland, on the wonderful island of Islay that I hope to be visiting next year. Whew. All right. That's it. We got a bunch of ground to cover. We've got 2 hours and 47 minutes exactly left of this. So we'll break that up over 2 weeks, and then we'll have the verdict, and we shall be done with OJ. Let's bring up the juice cam. Here we go. There's the top of Judge Ito's head. And ladies and gentlemen, and JKD Buck, we are off to the races.
Jury panel. Ladies and gentlemen, as I indicated to you earlier, argument is a very important.
Now, they had a big fight at the end of last week, the defense, and it was basically Marcia Clark and Barry Scheck going at it. They were arguing and casting aspersions on each other and their abilities to be a good lawyer, and whether or not the prosecution was testifying and bringing up things that weren't mentioned in trial, et cetera, et cetera. It was a pretty good blowout. Go back 4 weeks ago and watch it, but we're not going to go over it here. We're just going to pick it up right where we left off.
Part of the case, it's the opportunity of lawyers to actually bring everything together in a logical and coherent way. And I indicated to you that the lawyers may argue the evidence that is in the record and draw from that evidence reasonable inferences for you to consider. Those are the guidelines. I needed to discuss a few matters out of your presence with the lawyers. We're ready to proceed. Ms. Clark.
Thank you, Ron. Once again, so as I was saying, if there is evidence of a conspiracy, it would be my obligation to dismiss. Pure and simple. And I can go on to the next case.
Right out of the gate. Objections.
But there isn't.
Oh.
And in this case, we have... I'm going to finish what I have to say to you, and I'm going to do it as quickly as I can. Okay.
Uh-oh. Casting
what we have here is logic
at the defense.
And evidence and common sense, which when you weave them all together, you can see what the truth is. You can see what's really happening here. I'm going to start with a very simple example, and that is the arguments that were made to you about the notification of the coroner. You might remember the counsel made a big deal about the fact that the coroner wasn't called till late. And Mr. Cochran has repeatedly referred to the rush to judgment. Now, let me address that with you for a second. The rush to judgment. The argument has been made that when they went to Rockingham, what they really wanted to do was make an arrest, right?
Well, of course,
Rush
you
to
always want to
judgment.
arrest the bad
They had
guy.
it in mind that they were going to go there and arrest him, and he was a suspect. And there was a reference made to a remark made by Mr. Van Adder in January or February of this year that seemed to contradict what he was telling you about his state of mind. Now, I don't know about you folks, but what I do when I have a doubt, when I wonder about what somebody really means, whether I can believe them, I look what they do. Look what they do. Like we were all taught as kids, actions speak louder than words. Yes, they do. Yes, they do. People can say things. We all know they can, but let's see what they do. Now, what did they do? Okay, let's look
What
back
did who do?
at the evidence that is not contested,
You
the
do?
evidence that
Do?
that
You might
stands
be right.
unrefuted. They were out at Bundy. Commander Bushy told the initial detectives, get on out there.
Oh, and again, for those of you just joining, this that have never seen this before, and I'm sure everybody's seen this, and you're all tired of me because we bring it up every time we possibly can. This person up here in the far in the Caucasian man in the upper right hand corner, this is the man that's responsible for at least at least 3 of the 4 Kardashians. This is Robert Kardashian, parent of all of the Kardashians, except maybe one, and her alleged possible father may be a little bit closer to the judge. But yes, this is Robert Kardashian, head of the Kardashian clan. May he rest in peace.
Go and make notification at Rockingham. You know, that would be a problem for somebody who's famous, because if the media finds out, it's all over the place. That's a very painful thing. And Commander Bushy sure doesn't want it to happen on his watch, that would happen in this case. So he told him, go out there. That's what he told you. Did they? No. They weren't sure if they were going to keep the case. I'm weaving the testimony for you together without reading from the transcript. You have it, though. I'm not going to bore you. But Detective Phillips did say, we weren't sure if we were going to keep the case if we had the resources. That was a real big problem with this case, because they only had, like, I think he said 4 or 6 detectives in homicide over in West LA. So they thought that it might be taken over by robbery homicide division downtown that has many, many more detectives and more resources. Before they act, before they move to make notification, which is an important thing to do in a homicide case, your first contact with next of kin is to go and make the notification, make that contact, establish that rapport. And there might be some information that you can get from the next of kin or the person you notify that could be very helpful to solving the case. The person could be a witness, okay? Now, especially in this case where they have children in common, he might know who she's dating or not.
Yes, the Dana Loves Zumba has pointed out that Kendall and Kylie are Bruce Jenner's kids. True, the Kardashian clan is Kourtney, Kim, possibly Khloe, and the always forgotten Rob Kardashian. So, as I said, that's the man back here, this Caucasian gentleman just above Marcia's head, is responsible for at least 3 of the 4 Kardashians, and possibly all of them. I don't know. Just saying. Some people think that her father may actually be a little bit closer to the front of the courtroom.
Not, because, you know, they're divorced, but they still have to have contact. He might know something. It's an important first contact for them to make. So whoever is the handling detective is the one that's supposed to go. This is the testimony you've already heard. I'm not telling you anything new. So they waited. They waited until they found out if robbery homicide was going to take the case. And sure enough, they did.
And it's my goal to
Van Adder and Lang
hook up with Ari Jacob and have
I guess
her
they showed up around
help me hunt down OJ.
4:30, I think it was. All right. So they were standing out there waiting for quite a long time.
That's my goal, to meet OJ.
When Van Adder and Lang got there, or in between, I think, when it was finally assigned to robbery homicide, Commander Bushy spoke to them again.
That's Nicole Brown
said,
sister.
Go to Rockingham.
That's Dominic Dunn.
How many times do I have to say this? Go and do it. So then finally, they still didn't go and do it. They still didn't run out there. Okay. That was, I can't remember. I think he said it was around the time. He couldn't be specific about the time. That's right. But he said he knew that Van Adder was there, that robbery homicide had taken over the case. Now, Van Adder didn't get there, I think, till 4 or so. The record will refresh your memory. I can't remember exactly, and I'm not trying to tell you I am. But it was that time. Even then, they didn't go immediately.
There's a little Gul Dukat working in there, but I think she looks more like
about
Kira.
5 o'clock when they finally went to Rockingham. Finally went there. Now, think about this. there were a lot of questions asked about why couldn't you have sent a rookie to go and make notification? Okay, now you know that doesn't make sense. If notification is an important thing, first of all, it has to be handled delicately, sensitively by people who have done this before, many times before, homicide detectives. It's one of the saddest parts of their job. They have to make these notifications every day, but they know how, and they know how to deal with it. Bless you. So they're going to go and do it themselves. It's an important contact. That's their job. That's their duty. Okay? So they can't send a rookie out to do it. But what should they do? Think about this now. If it is their intent to go out to Rockingham, make an arrest, because he's a suspect, there are certain things they should have done. Number one thing is you take backup. You don't go by yourself. You take backup. You take a couple of squad cars, you make notification downtown. Hey, we're going to arrest, and this is an important suspect, and this could be a big media event. You make plans, you make arrangements. They did nothing. Zip. They went out there and they took just the 4 detectives in their 2 cars. They went over to Rockingham. That's all they did. What else should they have done? Ask yourself. If they know that,
Shut up when there's an objection.
Overruled. They may argue reasonable inference from the evidence that is in the record. And has counsel have a seat.
your common sense will tell you I'm not misleading you. This makes sense. I'm talking logic. I'm also talking logic based on what the witnesses have told you.
Johnny's
You
upset.
know it when you hear it. Now, what else should they have done? If they're going to go make an arrest, that's going to take some time. They could really get wrapped up. They could do questioning. They could take downtown. They could, the things that happen when someone gets arrested. So if they know they're going to take a long time, they have a crime scene that has to be processed. They have two dead people lying out there and all that evidence around. What would they do? They would go to somebody who's going to stay at the crime scene and they would say, call the coroner. We're going to be gone a while. Call the criminalist. We're going to be gone a while. We need you to get this evidence collected, and we won't be here because we're going to make an arrest.
Your Honor.
Did they do any of that? No. Now, what the evidence has shown is, and what they've testified to, and what their actions tell you is true, they expected to come right back. Two of them would stay with Mr. Simpson, taking care of him, taking him to the station to get his children, making the arrangements, and two would go back to Bundy and handle the crime scene. And their actions totally support that. If they expected to be gone a long time, they wouldn't all forego. Or they would tell someone else, take care of business for us, we're going to be gone. They didn't do that. What their actions tell you is, we're coming right back. It doesn't really matter if somebody isn't taking care of business and calling the coroner and calling the criminals. Logic.
Every day.
Logic. Look at their actions. Look at their actions. You don't trust the words? Look at what they do. That's what they did.
What did they do?
Right now, an argument was made to you about standing the Constitution on its head. And that's because I said, look, why don't they call these witnesses? There are witnesses they should logically call. Now, I'm talking about logic. I'm talking about reason. I'm talking about what do you expect? What would you like to hear? These are questions you're entitled to have answered. These are questions that you should consider. These are fair and reasonable questions. And these are questions that do not stand the Constitution.
This is Chewbacca. What's Chewbacca got to do with
I told
this?
you when I
Nothing.
first
That's why
argued
you
to
must
in
acquit.
the beginning of long arguments that they would be telling you many, many times, the defense, we don't have to prove anything. If you heard it once, you heard it 50 times. They did. That's what they said. And that's right. They don't. But when they do, but when they try to, then you have to evaluate their evidence the same as ours. There's no difference. The jury instructions govern all the witnesses. And so you look, what is the quality of evidence that I've been given by the defense? What witnesses have they called? What logical witness that you would expect
That's
to be
OJ's
called
mother
weren't
back there in
called?
turquoise.
That all tells you something. It's legitimate for you to consider it. You must consider it because, as I showed you in the jury instruction beyond a reasonable doubt, you must consider all of the evidence. That means everything that was done and not done.
Yeah, they considered all
And
of the
here's an
evidence for
example.
about 4 hours before coming back with an acquittal.
Final
Oops,
Paratus.
spoiler.
Remember that was the nurse. He drew the blood. That was their witness. Now, he was their witness because he was the cornerstone of their case. Very important to make you believe that there is missing blood. But then, now I think defense counsel made some reference to that, the notion that Hank Goldberg, secretly went out and interviewed him. What's secret? You know, if you have a question about this, ask the judge. No attorney for either side is required to give notification to the other side. Oh, I'm going to go interview my witness. That makes sense, doesn't it? They don't notify us. We don't notify them. We talk to them. We give them evidence of it. We give them a statement. Here, we talk to this guy. Here's the statement. That's what we do. Hank Goldberg went and talked to him. Mr. Parada said,
Jill
No,
says
I
Marcia
didn't
Clark is
measure.
the reason this
No,
case is
I
lost, in
didn't
my
look.
opinion.
and I
I think
realized
it's their
I was
whole deal
wrong.
of putting
I
Dennis
was trying to
Funk
be
on the
very
stand and
precise.
specifically putting Mark
Okay.
Furman on the stand.
Now, here's the syringe.
Whoever made that
You're gonna have
decision,
this back
most
there.
likely
You look at
Marcia
it.
Clark, is at fault.
And what he said was, I turn it over. I had it turned over and I couldn't see the numbers. And you'll see when you look at the numbers, all these little lines, unless you're sitting there like this, you're not going to be able to measure precisely how much.
They're
you
not
got
going to
in
look
there.
at it. They're coming back.
But if you have it
in a
turned
hurry.
over, you're really not going to know. Okay.
Oh, okay. We gotta pause because there's a very, very actual, real, valuable question here. Rare Ozzy says, "Is the whole trial on your site? I'd love to see it all." Warning: this trial went on for, like, the actual trial, including jury selection. It was much longer. The actual trial was 9 months long. It was 11 months with jury selection included. You don't want to watch the whole thing. What I've done and why I do this is, oh my God, we got 132 people here. I think that's more than we've ever had for any OJ Simpson trial we've done. What I've done with the OJ Simpson trial is it has two of my legendary defense lawyers on his team, Barry Scheck and F. Lee Bailey. F. Lee Bailey is the GOAT of defense lawyers, and Barry Scheck has a mind like a steel trap. What I did is I went through and I showed you some of the I showed you the opening statements, some of the prosecution witnesses, and their devastating cross-examination by the defense team. Not to change anybody's mind about is OJ innocent or guilty. This was like 28 years ago, almost 29 years ago. If you haven't made up your mind yet, whether he's innocent or guilty, I'm not going to do anything. And if you have made up your mind, I ain't going to change it, I don't think. But I wanted to show you how, because everybody's like, he's obviously guilty, but they found him not guilty. And I wanted to show you the parts of the trial that I believe show how masters of their craft, master defense lawyers, F. Lee Bailey and Barry Scheck, can dismantle witnesses and plant the seeds of reasonable doubt in the juror's mind. The cross-examination of Dennis Fung by Barry Scheck is what I consider to be the greatest cross-examination in living history. It was 8.5 days of brutal cross-examination, to the point where Dennis Fung, the LA criminologist, was so bamboozled by the end of his 8.5 days on the stand that he actually got off the stand, shook hands with, and hugged the defense team. That's how out of it he was. And Mark Furman, F. Lee Bailey crushed him and caught him in a lie about how he never uses the N-word. And Bailey was dropping some hard R's in court and proving that Mark Furman had used it at least 41 times on tape, and how he very likely planted evidence, how he found all of the important evidence alone in places where he wasn't supposed to be, et cetera, et cetera. So I've only covered actually a few weeks of the trial in nearly a year and a half. So I think I give a pretty good view of the trial and how master lawyers, masters of their craft, can introduce reasonable doubt into the minds of jurors. So that's what you'll see if you go back and watch all 63 episodes, including this. There'll be a total of 64 when we finish. So that's sort of a brief overview of what the OJ trial that I'm doing is all about. If I were to do this 2 hours a day and do the entire 9-month trial, I would literally die first. I would die of old age before we finish the entire trial. Yeah, so go back and watch. Just if I know I've had people tell me they've binge watched the entire thing, which is wild to me. I enjoy doing it every week, but I don't know if I could binge it all, but good on you if you can. There's some great stuff, and I quite enjoy it. And we're gonna do an entire trial next. This next trial we're gonna do this witchcraft triple murder trial. We're gonna do that from gavel to gavel because it was about a 3-week trial, so we can do that. So stay tuned for that starting in 2 weeks. But yeah, as Alan Wall said, it's a lesson in lawyering by two of the best at their craft, F. Lee Bailey and Barry Scheck. And with that, let's jump back into this. And we got 140 people here. That's awesome. And 80 likes, 60 of you. Just get down there and smash that like button and do the like poll and make sure you're still subscribed. And if and when any super chats come up, we'll just talk over Marcia because otherwise we'll be here
beyond
forever.
all of that, it just kind of makes sense. If no one tells you you must take this much blood, you're not going to look to take that much blood. You're going to take enough. You take enough for sampling, for testing, and that's what they did.
Yeah, well, they also wrote down how much they took, and then there was like, what was it, 1 milliliter was missing when you went back to test it, and that was right about the same time the 2 mysterious blood drops showed up on a back gate and a sock.
Now, phenylparalysis is not
suspicious much.
Truly a real important part of our case because we proved to you in many different ways the integrity of the evidence. I'm going to get into the blood evidence and why it's proven to have integrity in just a little bit. Let me start with hair and fiber, though.
Oh, God, hair and fiber. While they're doing that, Born Sinner says, I saw a documentary where Marcia says she begged her team not to ask OJ to try on the glove.
There were a number of misstatements made.
And she thinks that's why they lost the case. Oh, most definitely. There was, the Mark Furman, Dennis Fung were devastating to the case, but that putting on the glove was the absolute final nail in the coffin. And Johnny Cochran Jedi mind tricked Chris Darden, who you see here in the background. Jedi mind tricked him into doing it. Basically saying, "Oh, we're gonna have him put on the glove. We're gonna have him put on the glove. And if you don't do it, we're gonna have him put on the glove." And Darden wanted to be the hero. Darden wanted to be the one to go, yeah, put on the glove. Look at this. And then it didn't fit. And it was a total Jedi mind trick. He got so far up Chris Darden's backside, tricked him into doing it, and just absolutely sealed the case at that point.
To you yesterday by Mr. Scheck concerning the hair and fiber evidence. I'm going to go into just a couple of them. And one thing that Mr. Scheck said was that Mr. Diedrich and Dr. Lee agreed that hair and fiber association was weak association. Well, here's what Dr. Lee testified to. Page 43,168.
God, 43,000 pages of transcript.
Posed to Dr. Lee. Do you agree with the following statement? While it is difficult to make absolute individualizations in these areas, the trace analyst can make identifications with a high degree of certainty and can often establish partial individuality of a specimen with confidence based on experience and analytical results. Answer. I would say 80 to 90% that statement correct. They forgot one thing, depends on samples. Not all the sample you can reach that degree of certainty. Some of the sample, yes, you can.
God, these people
in other words,
horribly
it's a very
boring.
Good,
all of them.
What he said,
yeah, Alan was
can establish partial individuality with confidence. In other words, it's a very strong method of association. Now I'm going to show you the pictures, and you'll see why they make that strong statement about it.
See, she's trying to make points, and I think they're good points, but she's doing it in a dull, monotone, run-on sentence voice that's just got to be driving the jurors absolutely insane. I mean, Darden is just one of the worst speakers just to ever walk into a courtroom.
Remember, we showed you this during the trial. This is people.
See, and you should be crushing them with your evidence. We showed this, we showed this, we showed this, not going through charts and diagrams of various hair follicles, hairs and hair follicles and fibers and stuff like that. Don't bore the jury to death. And these jurors are already bored out of their damn minds.
480. Remember this? His known head hairs on the top row, and then the hairs from the knit cap at the bottom row. And you look at them and you compare and you see. Your eyes tell you. You don't need to look at x-rays. You don't need to look at autorads. These were the hairs in the knit cap found at the feet of Ron Goldman. This is testimony that was unrefuted. No defense expert came in to tell you this wasn't so. And equals 481.
Where is that?
Again, the defendant's known hairs. Hairs taken from the knit cap. Hair from Ron Goldman's shirt. You can see this.
Yeah, and? So what? Adara the Wholesome with the very first super chat of the day. Adara the Wholesome. Rip Johnny Cochran. This trial made me respect you. I know
Mr.
you're talking
Sheck
about
also
Johnny
told
Garden.
you that
I also chose to
the
remember him by
blue-black cotton
remembering his
fibers
appearance
that
in
were
the South
found
Park
on
season 2
Ron
episode
Goldman's
14,
shirt,
Chef
on the
Aid, wherein the
Rockingham
Chewbacca
glove,
defense was born.
and on the
That
defendant's
does make
socks
sense.
were very common. That's what he argued to you yesterday. That is not what the testimony said. Let me read to you what Doug Diedrich told you about this.
Let me read it in the most boring
Page
voice possible.
35,093. Question. Now you saw a lot of fibers in this case, correct? Answer, a lot, yes. Question. Was there something unusual about these particular blue-black cotton fibers that drew your attention or made you pay particular attention to them? Answer, yes. Well, cotton fibers themselves, they are common. There is a lot of cotton fibers out there. What gives cotton fibers significance is that when you add color to them in a specific way, some you see more, maybe less likely than others. These are actually, it is a real dark blue. It looks black, but in some areas the dye was not absorbed the same, and this may be where the yarns are attached to the fabric. The same thing appeared also on the fibers that were recovered from Ron Goldman's shirt, the bluish area, also present here. It was recovered from the defendant's socks. The bluish area here is starting to show.
So she's saying his
Some of
sock
these
fiber
areas
was on
can better be
shirt?
shown
What
using
is she
instrumental
showing?
techniques with color because the eyeball sees this as a shade of blue, this as a shade of blue, and so forth.
What's the point of this? What is it? How
And then
is
he
it
goes into
helping your
all of the
case?
methods that he used to examine these blue-black cotton fibers to determine that they did in fact share the same microscopic characteristics. And I was going to read it all to you, but it's just too long. There's a lot of tests that he used, and it had to do with the color, and it had to do with the dye, and it had to do with the appearance. And if you need to have it read back, please do.
Oh, his hand is in the way.
And if you don't want to read it, you can just see it. 487.
You just show that briefly to counsel.
Oh my God.
All right, thank you.
And Unhung Hero says, Jeff, you should have night streamed this trial. Works better than Ambien to knock me out. I don't want my viewers to go to sleep. I want them to be entertained and engaged. She's death to my channel. But by God, we're not giving up. We're gonna fight through the next 2 hours and whatever, 2.5 hours of her testimony over the next 2 weeks. We're gonna fight through it. Then we're gonna go on to a much more interesting case.
Now, there was also some discussion about the defendant having dandruff, if you recall.
Oops, I'm
And
sorry,
it was
I shouldn't
told
have
to you
cursed.
that the defendant always had dandruff in the off season. That is not what the testimony showed. Here's what the testimony actually showed about that. Page 37,441. Question. And sometimes in the summer, when you saw him take care of his hair, he would have dandruff, and sometimes he would not. Answer, that's correct.
OJ Simpson had dandruff,
That was his
therefore he's
barber.
guilty.
The other interesting thing that she told us is that unless you brush the hair vigorously, the dandruff does not come off. So I asked her, if you just brush his hair, the dandruff doesn't come off? Answer, right. Which means if you don't brush or comb the hair and it just falls off by itself, the dandruff doesn't come off. If you don't do anything to the hair, I guess it will just stay there. Now, The hairs in the cap did not have dandruff. And the defense wants you to believe it couldn't be his hair because he has dandruff. That is not what the testimony showed. That is not what the evidence showed. The evidence showed sometimes he does, sometimes he doesn't. But actually, even if he did, it wouldn't come off in the knit cap because you had to brush vigorously to get it out so that it would show. So what you have in the knit cap are his hairs, the naturally shed hairs that are his, because he wore the hat.
And thank you all 143 people that are here. 50 of you need to get down there and smash that like button. I know there's absolutely nothing to like about Marcia Clark's closing arguments, but, you know, help a dude out.
Jury instructions. I spoke to you a little bit about them before. There was one I didn't talk to you about. I want to mention now because I'm going to talk a little bit about Dr. Bodden and what he testified to. And that instruction is 2.80. Do you have another bench?
Speaking of which, I forgot my cigar over here. That relaxes me and makes me less fidgety. So this cigar is kind of crap. This is actually a Russian cigar.
Thank you.
It's a
You have a
special
few instructions.
thing.
It tells you about expert testimony, and this can be really helpful to you because I think I'm not alone in getting a little bit intimidated by experts. They know they have doctor in front of their names, and what do I know? But you shouldn't be. You shouldn't be. You are allowed to evaluate.
This is shitty. This is a horrible closing. Here's the prosecutor saying, I'm intimidated and scared of expert witnesses, but you shouldn't be. If you're scared, then the jury's going to be terrified. You should say, look, don't be scared. Don't be scared of experts with doctor and whatnot in front of their name, because I'm going to make this simple for you. I'll simplify what they told you. Then nobody has to be scared. I'm intimidated and scared by them, but you shouldn't be. That is a stupid, stupid thing to say, Marcia. She is so frustrating.
The opinion of a doctor, and if it doesn't make sense, you can say, you don't make sense. I don't believe you. It doesn't matter if they have doctor or PhD before or after their name. You get to evaluate it because if it's not logical, if it doesn't make sense, it doesn't matter what their title is. And that's basically what the instruction says. 2.80, you'll have it back there. And it says the following: you are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. You may disregard any such opinion if you find it to be unreasonable. Okay? So what that tells you is, don't be intimidated by the title. You know what makes sense. And if you find it to be unreasonable, toss it. Okay? Dr. Bodden told you some things that were that made absolutely no sense. They defy the laws of gravity. What am I talking about? I'm not going to drag all the pictures out here right now. You'll have them back there.
Oh yeah, because of the Chewbacca defense. Every someone says it makes no sense, we do Chewbacca. So there you go.
If you want to verify this. One thing that he said that I just couldn't believe I was hearing is that the jugular vein cut was the one that caused the blood on Ron Goldman's pants. Now, think about this. This is jumping blood because there isn't a big, then it should be jumping down the shirt, right? Logic tells you that if he's bleeding from the neck, it's going to drip down his shirt and then get to his pants. You look at his shirt.
Unless he's crumpled over because he just got his fucking,
shirt
his
is not blood soaked in front over the place where the pants are all blood soaked. So it's very obvious that where the blood came from is the stab wound in the hip. And Dr. Bodden's testimony on that makes absolutely no sense. Another thing that makes no sense, that actually disregards what gravity tells you must be true, but what Dr. Lakshmanan told you as well.
Got to make another quick. People have been asking about Chandler. Chandler is now, as I'm studying for her LSAT test or law school test and doing other things. So yeah, she's doing her own thing here now. So, but I'm sure there'll be other collabs in the future. Just no more OJs until she gets things settled.
Well, and he is medically qualified, and that is this. He also said. And this is how he gives you this big time frame, which, by the way, makes no sense all by itself. He said that there was a period of between 5 to 15 minutes from the time that The neck wound was inflicted
Adara the
to the
Wholesome.
time that
I need
the
about
chest
350.
wound was
Jeff,
inflicted.
Loch Ness
And
Monster.
he based that on the very small amount of blood found in the
Thanks.
chest cavity on Ron Goldman's right side. Okay. In other words, what he's basically
Thanks,
telling you
Adara.
is that blood
You make me
pressure
laugh.
had so dropped as a result of this jugular wound. He bled out so much that by the time he got stabbed here, it had to be about 10 minutes later. And that's why there's so little blood in the cavity.
10 minutes?
Okay.
How long did this fight take, Marcia?
But Ron
10
Goldman
minutes?
was lying on his right side and bleeding out so much, you can actually see it in the photographs you'll have back there. There was a tree stump that I think has the number 106 on it.
Tree
You have
stump,
the
like
photographs.
tree fitty?
Look at this, please, because it's blood soaked. And what they did
Yes, Brad.
before they got the actual
Yes,
reference
they
vials
are.
of the
They're
victim's blood
dating.
from the coroner,
Not the
was
cable
they
guy,
went
the
and they
DUI
took
guy.
blood samples from the place where the victims were lying, so they would have some idea ahead of time as to what the victim's blood types were. So they took a swatch from the tree stump near Ron, because obviously that was his blood. They also took a swatch from the pool of blood that Ms. Brown was lying in. And that was her reference sample taken from the crime scene. That's how much he was bleeding out. Dr. Bodden doesn't believe in gravity, doesn't believe that that's
come
why
on.
he had so little blood in his cavity, doesn't believe that somebody lying on their right side is going to bleed out if he's lying there for a while, and says there's so little blood there, that means he was already near death. And that means the jugular wound had been bleeding for quite a long time. And that's ridiculous. I'll tell you why
Marcia,
else. You don't even have to be a
Yeah,
doctor
tell
to
us
figure this
why,
one out.
because
Somebody
you bleed
commits
out
murder, they're going to
pretty
hang
dang
around.
quick from a jugular
What
cut.
was he doing for 10 minutes? Between the time that he inflicts the jugular cut and the time that he inflicts the chest cavity, if you believe Dr. Bodden, he's got 10 minutes to kill. The door is standing open. There's no
kill?
evidence of ransacking.
Hey, Frank.
There's no evidence of disturbance. What's he doing? Playing solitaire out there? What's he going to? That's ridiculous. What are they asking you to buy? That's why I'm saying, look at the jury instruction. You may disregard any such opinion if you find it to be unreasonable. Ladies and gentlemen, that is one of the most unreasonable things I think I've ever heard any doctor say. That is ridiculous.
Uh-oh, we're frozen.
Could you slow down just a little?
I'm sorry.
She's
I'm
she's
trying to
getting
get it
upset.
over
And the
with.
court
So,
clerk can't
I'm
keep
sorry.
up.
Sorry, Chris. While we're on expert testimony, EDTA, very, very briefly, okay? You were told during argument that a letter was sent to Agent Martz asking him to refute the allegation that the blood was planted. That is not what the letter says.
I do not
The letter
know.
says,
I think I heard something about Glenn Rogers. I think Eric Hunley did a show about it.
I didn't bring the exhibit number, Your Honor, I just
All
have the
right.
letter.
Supply that for us.
Doesn't have the exhibit number. Way to be prepared, Marcia Clark, for the most important closing argument you're ever going to give in your entire effing life. Way not to be prepared.
All right. What just
Nope, there was no screaming or yelling. There was a
Proceed.
dog barking, allegedly.
The question posed was, we would like you to test these items for the presence/absence of EDTA in order to refute the possibility that the stain on the sock could have come from this reference sample. Now, what is the point of that?
Yes, tell us.
When we heard that the defense was going to make this outrageous allegation, I thought, well, I won't close my mind to anything. Let's find out. Right.
be careful here.
So we
careful.
sent
The judge is
the
warning
reference
her.
samples, and we sent the sock, and we sent the rear gate samples to Agent Martz for testing. Let's find out. And what was the result?
Now, again, here's the deal. Oh, let's get the result first.
No EDTA. No big surprise, but no EDTA. Now, he came in and he testified, and he showed you these charts. And I want to show them to you one more time.
See, we have dueling experts here. Because what happened was they took a photograph of this back gate. And there was like one tiny brown speck on it. And then they went back weeks later to re-inspect the gate. And lo and behold, they have another picture with some blood spots on the back gate. Paging Dr. Freud. So some blood stains on the back gate that weren't there in the pictures that were taken at the time of the murder. And depending who you ask, one side says it had chemical preservatives that are used to preserve blood samples in evidence preservation, and Marcia Clark saying it didn't have it. And again, this might coincide with the fact that the guy who drew the blood testified for the defense and said from the time he drew the blood until now, then there is, like, I think I said, 1 milliliter missing. I mean, there was like a tiny amount missing, a couple of drops. Suspicious. And they also suddenly mysteriously one day found blood on a sock that they'd had in their possession for several weeks too. So that's what they're talking about here.
Because it made it so clear. And perhaps you may recall, he tested his own blood, unpreserved. He tested the evidence on the gate, and he tested the blood on the sock. And guess what? His own unpreserved blood and the gate stain and the sock stain all came out looking the same. They came out looking like this. We taped all their charts together. So what you see here is the results of all of those things. That's 544E, Your Honor.
Thank you.
Okay. That was Agent Martz's own blood and the evidence. That means the rear gate blood and the sock blood. That's what that looked like. So unpreserved blood and the evidence had all those jagged peaks. Okay. Here's 544F. This is what it looks like when we have EDTA preserved blood. All the same. That stuff all comes from the test tube with EDTA in it. Does that look anything like the jagged peaks that we just showed you? That's pretty easy. But Dr. Reeders thought he could get you to blind your eyes and listen to his title and say, well, gee, I'm not qualified. Maybe they do look alike. I mean, it's ridiculous,
yeah, well,
but he did that.
The Bronco chase would actually be a little bit more exciting than this.
But what's even worse, and what shows you really that this
slowest
is a man
high-speed chase
whose opinion
in history
is for sale, is
that
that
I
his
watched
initial report said,
on television,
I
beginning
found
to
2
end.
of the 3 ions on the gate and on the sock.
The ion drive.
And he thought that was going to be good enough for him to say, well, could be consistent with, and he could slide around with that. One unfortunate thing that happened after he wrote that report was Agent Martz then said, gosh, I wonder what it'd be like if I tested my own blood without any EDTA in it. Took blood out of his arm, and he went and he tested it with not an EDTA, just regular old blood. And guess what? It looked just like the gate. It looked just like the sock.
Just like it?
Well, when Dr. Reeders found that out, he realized, I've got to do something because they've just proven me completely wrong. So what he did for the first time on the witness stand was he got up there and he said, oops, I found another ion on the sock. And he tried to show you that one of those peaks matches something else. It was really reprehensible. And I know I got a little bit excited with Dr. Reeders, but this is a man does not forget where he comes from. Does not forget what he did
Where he
before.
comes
I asked
from?
him questions about this other case, the case of poisoning.
You may recall the evidence.
Case of oleander poisoning, in which he was asked by the district attorneys of Ventura County and this county to find out whether a man died of natural causes or had been poisoned to death. Now, that sounds pretty serious, doesn't it?
Poisoned by
That's
a
a murder
flower.
charge.
That's cool.
That can or cannot be brought
Oleander.
based on what his test shows. And he did preliminary screening tests. He did not use state-of-the-art. He didn't even know what state-of-the-art was available at the time. And he came back with the answer, yes, poison is present. Poison is present. And had the DA and the defense attorney not joined together to go out and find an expert who had much more sophisticated equipment, who could do definitive testing, an innocent man would have gone to prison for murder. Because Dr. Reeders was so sloppy and so out of date and had an opinion for hire for whoever was bidding,
It's hot, Marcia.
that's what would have happened. But fortunately, the DA said, no, we're going to go and check that again.
Counsel, that does go beyond the scope.
Shut up, Marcia.
And that's why you have to view very, very carefully the experts. See if they make sense. See if you can rely on them. See if they are
That was close
believable.
to
See if
Chewbacca.
they are logical. And consider the fact that they're for hire. Sure, that makes a difference. Dr. Bodden, who came and told you that gravity doesn't work, paid over $100,000 in this case. He's very charming. He's very affable. I enjoyed seeing him in court, but hearing him was something else. Over $100,000 he got paid in this case.
And it was worth every goddamn penny, apparently. Ozzy Overlord is the man to talk to about the backpack
There was also
murders.
a reference
Dude
made
knows
to
a
you.
lot about
Mr.
it.
Darden began to address it about golf balls. You may recall.
We've got the biggest golf balls of them
And then it was
all.
argued as well. It was argued that the defendant had that little dark bag
The
that
OJ
he
family
insisted
there?
on picking up, and that was for carrying golf balls to the tournament in Chicago. Now, first of all, what kind of sense does that make? You take your own golf balls to a golf tournament? Don't you think they're going to give you some there? But it's worse than that because that's not what the evidence showed.
Marcia! How to say you've never gone golfing without saying you've never been golfing? Well, oh yeah, like he takes his own golf balls. Like they're not going to give him some golf balls there? Dude, golfers always bring their own damn balls. They have their own balls for a reason.
Alan Park was specifically asked about that. Can you tell us, sir, whether you saw any golf balls in that lawn area that night? Answer, no. Cato was asked the same question.
Cato the dog or Cato the witness?
Did you ever see balls in relationship to a bag that was similar to the bag you saw in the driveway on June the 12th? No, I don't think so. I don't remember seeing that. I think there were balls in the garage, kind of just balls that were there.
Where are your balls, Marcia?
And that was a question asked by Mr. Shapiro of Cato Kalin. So not only doesn't it make any sense, but there's no evidence to support it at all. Now, there was something else said to you, Represented, that Mr. Kalin and pictures and a videotape also refute. And that is a side door. You may recall that defense counsel mentioned to you, why would it be Mr. Simpson walking in through that front door when Alan Park was sitting out there watching him? He could have gone in from the side. Not true. And the evidence proves it's not true. First of all, Mr. Kalin testified that the laundry room referred to by counsel was not really used. But we have better than that for you, ladies and gentlemen. We have a videotape. We have that inventory videotape that counsel brought in that shows that door, that shows on June 13th that there were things, a little step ladder and stuff like that in front of the door, which gives you a clear indication that door was not in use. And that's the condition of that area on the afternoon of June the 13th. Do we have a clip?
What exhibit is
Bless
this?
you.
What exhibit is this,
What exhibit?
Mr. Fairtlow? All right, thank you, Mr. Wood.
Can we see it too? Marcia. You guys hear my dog chewing the bone over here? Strawberry's chewing the bone literally on top of, she just knows where to chew the bone to make the most noise. And it's right on the on this aluminum railing for the open and shutting of the sliding door that leads to my veranda.
Oops, back up. That was quick. Okay, see the laundry room in there. See that stepladder? What? See the stepladder? See the bag of laundry? It's stacked in front of the door.
Overruled. Counsel, it speaks for itself. All right, counters at 3:01 p.m. Thank you, Counsel.
Thank you.
You're welcome.
Now, do you put a stepladder, do you put a basket of laundry in front of a door that you use? No, obviously not. So there was no other way in. And that is why Alan Park saw the defendant walking in the door that night. And I'm going to tell you something, ladies and gentlemen, that was the defining moment of this trial. That was the one. Because when you understand that the defendant was out that night, when you understand that he lied to Alan Park about being asleep, when you understand that that Bronco was moved and that he was out in that Bronco that night, and that 10:03 call to Paula Barbieri is because he was out there making that phone call, then you understand how the defense falls apart. Then you understand where he was when his whereabouts are unaccounted for. And Alan Park's testimony is unrefuted. Alan Park came in and told us the truth, and he told it consistently. Bronco was not there, and neither was the defendant until 10:54. Excuse me, thumbs on the wall, 10:52. Now, that's one more important point.
Overruled, Counsel.
That's another important point, and this is why phone records are a good thing. And you'll have the testimony. I'm not going to read to you anymore. You're probably tired of hearing that.
We're tired of hearing you. It doesn't
You
matter
have it in
what
the
you're
record.
saying. We're just
I
tired of hearing
asked
you.
specifically, Cato, did you look at a clock? Did you look at your watch when you heard that thumping noise on your wall? No, I didn't. So is this an estimate? Yes, it's an estimate. He's estimating because he's not looking at what time it is. He says, I called Rachel around this time. About a half an hour later, I heard the thumps. It's an estimate. We had to go with that until we realized that Alan Park had a phone record. He had a phone record that said when he made a call and said when the call ended. And it was at the end of that call to his boss or from his boss that he saw Cato Kalin out in the side yard. And Cato Kalin told you, and it's unrefuted and it's uncontested, that it was 2 to 3 minutes after the thumping that he was out in that side yard. That's what he told you. And that means that the thumping occurred at 10:52. And then Alan Park saw Cato in the side yard at 10:54 at the same time as he saw the defendant walking in the door, 10:54. That means.
All right, we're going to take a little bit of a break here. We're at the halfway point. We only got through 40 minutes of it, so we still have 2 hours left. Again, we're breaking this up into 2 weeks. Let's just have a little palate cleanser, sort of get our brains clear from Marcia Clark's somehow simultaneously monotone but grating voice. Let's shake it off a little bit. We got 148 people. I think this is the largest audience we've ever had for OJ's Thursday. 152 now, right? We're right in the middle of the OJ closing arguments. This is the very end of the closing arguments by Marcia Clark. This is where she's supposed to be dragging us in, captivating us with her narrative and making us go, holy crap, you're right. The defense is wrong. There is no reasonable doubt in this case. OJ should go away for the rest of his life, but she's boring them to tears with her evidence and her monotone voice, yet somehow grating voice. I mean, between her and Christopher Darden, hands down the worst opening and closing that I can remember. I mean, insofar as being involved in very, very important cases go. They're just bad. They're just bad at speaking. They might have great legal minds, but they're very, very bad at speaking and conveying things simply and directly. Let's look at our like and subscribe poll. For those of you that are just joining us, make sure you hit that like button and subscribe if you haven't already done so. Please, 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 please. But please don't unsubscribe because of this. We've got one more week of this. Then we're going to go on to a witchcraft triple murder from Florida. So don't miss that. We'll cover that gavel to gavel. Just don't unsubscribe because you're like, oh my God, what the hell is this? Stick with us. And if you just make sure you're subscribed, hit the like button and vote in our OJ. We haven't done this for about a month. So OJ's back. 42% of you said, yay. 24% of you said, yay. 9% of you said, yes, give me that sweet Marcia Clark. And 24% of you said, I'll miss Donald Sutherland. Yeah, we've only got another hour before we have we have an hour within which to have a Donald Sutherland sighting. So stay tuned for that. We'll see if we get a Donald Sutherland sighting or not.
That 2 minutes after the thumping, the defendant is going into his house. And that means the thumping was done by the defendant. And they want to make fun of the fact that he ran into an air conditioner because it's his property and wouldn't he know better? Well, I don't think that he hung out on the South Pathway a whole lot. That's not where Mr. Simpson would go. That's where a repairman would go. Maybe a maid would go. He doesn't go down there. And anyway, that dark and
come on.
That dark
Overruled.
and that narrow little pathway in a hurry.
Overruled. In what way was it ever introduced into testimony that he doesn't go down that pathway? That was pure speculation. That was pure BS. It was absolutely a statement that had no evidentiary backing whatsoever. And that was overruled.
When you're pressed and you're frantic, you're not going to be looking to see everything that's coming. You're running. He's in a hurry. And that's why that happens. Now, there was also some statement about there was nothing around that glove, but Dr. Lee said differently. Page 43,200. Question. Now, in addition to that, doctor, when you were at the Rockingham location, did you have occasion to find any item that in your forensic opinion was consistent or appeared to be blood in the area of air conditioning unit near Cato Kalin's house? Answer, yes, sir.
Whoa.
It's in the record, Your Honor.
No. With the court report, please.
All right. Marcia Clark is PO'd. She got called to the bench. Let's see if she gets to go over that again, or if the judge is looking pissed at somebody. Is he looking pissed at Marcia, or is he looking pissed at the defense? Let's find out.
All right. Thank you, counsel.
It was also represented that Dr. Lee.
He was pissed at Marcia. Let's change the subject because the judge told me to.
And Dr. Bodden both agreed that the amount of struggle would have been a very long one. Dr. Lee, in fact, didn't say that. He said something a lot less certain than that. And I'll read to you what he said. Can you tell us blow by blow what happened here? Answer, no, I cannot. That's a good question. Question, all right, thank you. And doctor, would it be fair to say that if we cannot tell blow by blow what happened here, you cannot tell blow by blow what happened, then it's difficult to give any kind of a scientific estimation of time? Answer, that's correct. That's what Dr. Lee said. Now, with respect to Dr. Bodden, it was represented to you that Dr. Bodden said the perpetrator would have been covered in blood. That's not true. You can have all of Dr. Bodden's testimony read back. I went and looked at it. It's not there. He didn't say that. He didn't say it. Not only that, but their own expert, Mr. McDonnell, had some interesting things to say about what kind of blood or how much blood you'd ever expect to find. And matter of fact, we read the title into the record. Absence of evidence is not evidence of absence. This makes sense. A crime can happen in many different ways. Use your logic, use your common sense. If you're standing behind somebody, cutting their throat, they're bleeding out, and they're not bleeding on you. So you'll get some on your hands, maybe you'll get a little bit of spatter, but you're not going to be covered in blood, and you're certainly not going to be covered in the kind of blood that you're going to track into the Bronco because it isn't getting on your back.
You literally sliced his neck wide open, and then you cut, oh my Lord, Nicole Brown Simpson's neck was cut so deeply that there were scratch marks on the vertebrae at the back of her neck. That her spine was basically the only thing keeping her head on. And same thing happened to him with multiple stab wounds. And just because you're standing behind them, you're not going to get any blood on you? Marcia, nobody believes that.
And that's why when you think about this, think about it logically, but don't let the record be misrepresented. You want it read back, they will do it for you. They will do it for you. And don't hesitate to ask, ladies and gentlemen. Don't hesitate. Most important thing is that you base your decision on what's there, what's really there, not on what some lawyer tells you is there, not on what you wish was there or I wish was there. What's there? I know you'll do that. Do you want me to break?
Yeah, take a break at this point. All right, ladies and gentlemen, we're going to take our noon recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30.
All right, but
All
thankfully,
parties are again
there we
present.
go. We're back already.
Jury is not present.
Oh, they've got some stuff to argue about without the jury being there. Cool.
Mr. Scheck, you wanted to be heard on page 43-200.
Yes, sir. A few things to say about that. First point to be made is that I think in Ms. Clark's argument, she started to say that there was a statement, there was nothing around the glove, but Dr. Lee stated differently. Now she starts with the question, Dr. Lee, when you were at the Rockingham location, did you have occasion to find any item that your forensic opinion was consistent or appeared to be blood in the area of the air conditioning unit near Cato's house? Answer, yes, sir. That's all that's in the record at this point. Now, as the court noted at the bench, I would say there's three reasons at least that this was improper comment.
Is this normal for closing arguments, sending out the jury? No, it's not. No, yeah, not at all.
And that we should have an instruction to the jury, which is my request, that there is no evidence in this case Dr. Lee found blood on the air conditioner. And it's for at least these three reasons. Number one, there is a clear ruling in this case by this court that we've all had to live by, that presumptive tests are not admissible for showing that blood was present. And that is a clear ruling. There was a ruling that in the impeachment of Dennis Fung, that I had opened the door with respect to the Bronco, and the court made a limited finding that they could offer testimony about the extent of presumptive testing in the Bronco. So they know that that rule is in effect, and we've all lived with it and been very careful with it since. So that's point number one. Point number two, as the court noted at the bench, when one goes on to read the rest of the testimony of Dr. Lee in this area, the answers that were elicited were not that he had found blood on the air conditioning when Mr. Goldberg went on and continued asking him the question. And in fact, as I had noted on the record, and I'll get to the third point here, that he cut off Dr. Lee when Dr. Lee was about to give a further explanation when he indicated that he had done presumptive tests on the doorknobs, some sink traps, and air conditioner. And then Mr. Goldberg says, I'm just asking about the air conditioner. Answer, I saw in different places, and that's just about tests. And then Mr. Goldberg said, that's all right, Your Honor, I'll move on. I think he answered the question. Now,
Hey,
I
Colin,
came
welcome.
back the next day.
Report by Dr. Lee that says that he did any testing there?
Yes, he did presumptive testing there. But I came back the next day, and it said 43380 of the record. And what happened, Your Honor, is that I indicated to the court at that point, have you read this?
No, I didn't. I don't have the 43380.
Oh.
Mr. Byrne, give me the next volume 214, please.
Yes. I came back the next day, Your Honor. I think it actually starts at 43379. I came back the next day and made an objection on the record. And what I pointed out was that when I listened to I had thought that when Mr. Goldberg at this time, this is what I indicated on the record, said, that's enough, Dr. Lee, that what he was doing was trying to cut off the witness so there would not be testimony about presumptive testing, which would have violated the court's rule. And I thought that that's what he was doing. When I listened again the next night to the tape, because frankly, all these commentators were saying, oh, there's evidence of blood on the air conditioner.
You didn't really listen to those people, did you?
Well, no, I listened to the tape of the testimony. And when I listened to the taste of the testimony and the implication, I became concerned.
What page?
I think it starts at 43379 and goes on to 43380.
What? The mainstream media was misinterpreting and lying about what was testified to in court? No, mainstream media would never do something like that.
All right, proceed.
Do you see where I'm beginning? It's just before we took up the issue of the Furman tapes.
Oh, we have an out of focus Donald Sutherland in the background there. We're getting close.
Should I read it or is the court's reading?
I'm reading it right now.
Okay.
Oh, maybe that's our opportunity. We'll have to 47:30. Have to remember that for a timestamp in case we have to go. Oh, Mr. Goldberg. Now what? Hank, my man, you are so
All right,
out
I'll
of
read
your
the 43379 through 43381.
All right, so as that, I think, record indicates that I immediately approached the court and I said that I was fearful that, even though it wasn't explicitly stated on the record, that the prosecution might argue that there was blood
Mr.
found
Goldman,
on the air conditioning from the way that questions and answers were brought out and the way Mr. Goldman cut them off, and that I had misinterpreted Mr. Goldberg. He was cutting it off for purposes of putting this inference, which was improper in the first place because of the ruling on presumptive tests in the record, instead of trying to cut Dr. Lee off before he got into an area that was improper. And in fact, as I indicate in the record, that Dr. Lee was about to say that presumptive tests on sink traps, metal surfaces like air conditioners, doorknobs, and on that kind will always give false positives because of the nature of the metal surface and the bacteria, et cetera, which was what he was about to testify to, and they knew it because in interviews with Dr. Lee, that's what he had said. In any event, I won't, that's what Dr. Lee told me, and I offered to bring in an affidavit to that effect. And then the court indicated, as I put that objection on the record, and it was clear, and I thought, in effect, the court had ruled on that with respect to indicating to the people that that timely objection had been made on the record, and if they wanted to come forward and make this an argument, they were going to have to present arguments to the court that this was a fair inference from the evidence. I thought that's how the record stands right now. And they should, and this kind of comment, given the fact that the court had made a clear ruling in this case that presumptive tests are not proof of blood, number one. Number two, that the testimony itself does not support that contention. Number three, there was a timely objection noted on the record to the court, giving the prosecutors clear warning that if they wanted to make this argument, they better come in here and persuade the court that it was fair comment on the record. All of that being said, it seems to me highly improper and against the rulings of this court for them now to argue that there's blood on the air conditioner reading these questions and answers. It's not what the record states. It's not what the ruling this court is. It's misleading to the jury, and we're entitled to a curative instruction to the effect that there is no evidence that Dr. Lee found blood on the air conditioner. Highly improper argument, clear misconduct.
Ms. Clark.
I'm going to allow Mr. Goldberg to address it since he was the one that did the questioning. But I remind the court that the record says exactly what I read to the jury.
Thank you, Your Honor. Good afternoon.
Good afternoon, Ms. Goldberg.
Hank, Marcia and Chris are bad. You're not even in the conversation, my friend.
Issue of presumptive blood testing is one that we've addressed on a number of occasions with Your Honor. And the state of the record was that presumptive blood testing does not come in. We have abided by that, although the defense has not. They asked Mr. Lee questions about the walkway with respect to parallel line imprints on June the 25th that he photographed. Those were presumptively tested. There were no confirmatory tests. Dr. Lee offered the opinion that they were blood, in his opinion, based upon his forensic knowledge, and was not specifically asked by counsel to testify that he had done blood testing, that that's how he knew. So he was basically relying on his generalized training and experience. It looks like blood, therefore it is blood. The basis for that opinion we know outside of the record is a presumptive blood test. That came in, the court allowed it in. Then with Mr. Bodziak, counsel asked again questions about Mr. Lee's presumptive blood testing. and even called it that, blood testing, even though Mr. Scheck and I had an agreement outside the record that he would not raise the subject of presumptive blood testing with Mr. Bodziak without first clearing it with the court. And he just went ahead and did it on 2 occasions. I put before the jury the fact that presumptive blood.
And now, thankfully, remember, the jury is actually not in the courtroom right now. This is all outside the presence of the jury, so we can't bore the jury to death.
Testing has taken place. So I don't understand all the ins and outs and the exceptions and the rights and the wrongs with respect to the court's ruling. All I know is that it seems to be that.
What is wrong with these people? I can't understand the court's ruling, but I mean, who says that? I mean, listen to this.
And outs and the exceptions and the rights and the wrongs and outs and the again questions about Mr. Lee's presumptive blood testing.
Who says this?
And even called it that, blood testing, even though Mr. Scheck and I had an agreement outside the record that he would not raise the subject of presumptive blood testing with Mr. Bodziak without first clearing it with the court. And he just went ahead and did it on 2 occasions. I put before the jury the fact that presumptive blood testing has taken place. So I don't understand all the ins and outs and the exceptions and the rights and the wrongs with respect to the court's ruling. All I know is that it seems to be that when the defense wants to establish that something's blood, they don't seem to have difficulty doing it, even if the only basis for it is a presumptive blood test. And that being the case, we believed properly that we could do the same thing. Now, in this question that I asked Dr. Lee, I did not ask him about presumptive blood tests. I simply asked him, all right, now in addition to that, doctor, when you were at Rockingham location, did you have occasion to find any item that in your forensic opinion was consistent or appeared to be blood in the area of the air conditioning next to Cato Kalin's house? Answer, yes, sir. No question about forensic blood test. I'm asking him based on his experience and training as a forensic serologist, a very highly regarded one, whether it appeared to be and was based upon his forensic opinion. Then I asked him, and was that something that you believe that you thought appeared to be blood? Answer, I test some doorknobs, some sink traps, and air conditioner. I'm just asking you about the air conditioner. I saw in different places. Period. There's no indication from the transcript that I cut him off. And I said, that's all right, Your Honor. I will move on because I was fearful that he was going to start talking about presumptive blood testing, which he had not to heretofore. He simply told what appeared to be the case and what his opinion was as a forensic expert. Now, the court has allowed police officers to come in and say something appeared to be blood, or I thought something was blood, or even something was blood. And we know California courts allowed this, and Your Honor has allowed this in this trial. And I don't know why the world's perhaps most highly regarded forensic serologist, Dr. Henry Lee, can't come in here and tell us that something based upon his experience, his training, and his observations appeared to be blood. That's what this is. Now, as to the good faith belief, other than that it's in the record, and Dr. Lee has never been shy about trying to qualify and explain his answers. We also have a good faith basis because we have a report in which he said the same thing, that he tested this with orthotolidine test, which is highly reliable, which Dr. Lee regards to be reliable, and that it got a positive. I do not believe that I ever spoke to Dr. Lee about this question in my conversations with him at all. And that.
All right, Mr. Goldman, let me ask you this. Did he indicate that he saw something that appeared to him to be blood, and then he tested it with orthotolidine?
In where?
In his report.
In his report, there was a red stain that he tested and with orthotolidine test, and
on the air conditioner. On
the air conditioner, and it was positive for blood. So that was the good faith basis for my question. Now, on the as to the materials that are starting on 43-380, 79 of the transcript, I was unaware of this, that this conversation even took place, because I was not in court during it, and was not aware until counsel made this argument during Ms. Clark's argument. I know how Your Honor has conducted this case, and I know, based upon the experience that I've had in this court, that Your Honor would not have ruled on an issue like this without my being here, and you did not rule. Because this was my area, it was my witness, I knew this testimony, and I would be the person who was prepared to deal with it. Now, on 43-381, Your Honor says basically,
Not basically, what did Your Honor say?
well, Mr. Scheck says on 43-380, lines 27 to 28, I just want to make clear that we have an objection to that. And then Your Honor says, all right. And then on 43-381, lines 13 through 14.
Is there anybody on the
Your Honor
prosecution that
says,
knows how to
this is a
speak
comment for the
dynamically?
purposes of making a timely objection. I take it then, answered by Mr. Scheck, right. The court, all right, let's launch into the McKinney matter. And then you continue on with the 402 hearing on McKinney. So there is no ruling whatsoever with respect to this issue. If counsel wanted to make a motion to strike, I suppose that could have been done. We've closed evidence. We have introduced all of our exhibits. Ms. Clark is arguing about something that is in the record. She read it verbatim. She is entitled to do this under the court's rulings. And I do not see any basis whatsoever to prevent Ms. Clark from continuing on this line very briefly of argument. It's an important point because it's directly contradictory to what Mr. Cochran represented to this jury, and that she should be allowed to proceed on this issue.
Don't hurt him, Barry. Don't hurt him. Don't
First of
hurt
all,
him.
It would seem to me that there's a clear question of waiver as to the whole argument he just made now, for a very simple reason. I came forward and put this objection on the record the next day, indicating that it would not be Dr. Lee's testimony that that was blood because of the false positives from testing sink trap strains, et cetera. And that would have been his answer to the question. And the record is ambiguous and misleading with respect to that because he cut us the answer. So I put them on notice. It is not an excuse that can be tolerated at law that somebody sitting at this table the very next day after Dr. Lee got off the witness stand didn't go upstairs and tell Mr. Goldberg that this was said so he could come back down and we could settle the record on this issue and it could be clear what could be offered in closing argument and what couldn't be. That is not an excuse. Lack of continuity in the district attorney's office or the fact that nobody will call him up so he can come down and argue this as though the rest of them here are incapable or don't understand this issue is not an answer. It's
That's how you make an argument to a judge, prosecution. Holy crap. Whether Barry Scheck is right or wrong, he makes me just want to go, all right, you're correct. That's how you argue. That's how you give an impassioned argument on behalf of your client.
clearly waived. It is clearly waived. And what is particularly nefarious is that all of a sudden this issue arises during rebuttal. This is planned, Your Honor. It was exactly what I objected to. It is an unfair inference from the evidence. It is not supported by the record, even of the questions and answers, and it violates the clear instruction that we were all operating under here. It is in bad faith because I indicated that would not be the answer that Dr. Lee gave to the question. And it is quite different to be saying at certain points in time, I look at stain and I say, the black imprints could be consistent with blood. And they can certainly make objections and settle the record at that point. I made my objection. I made it clear. The ruling was clear. It is outrageous for them to be arguing that this is blood on the air conditioner from this part of the transcript. When the record was made, their opportunity to correct it was there. They have to come into this court, and it's just outrageous.
All right. Thank you, counsel. The question was to Dr. Lee, did he see anything that in his opinion was consistent with or appeared to be blood in the area of the air conditioning unit near Cato Kalin's bedroom? And the answer was yes. And then the question later was focused back on the air conditioner. And the answer was, I saw in different places. And that's the state of the record. There is no mention of presumptive testing that was done. Although Dr. Lee's answer just says I test some doorknobs, some sink traps, and air conditioner. And I accept the representations of counsel that what was done is the orthotolidine tests. The fact that Dr. Lee, I think, is competent to say I saw something that appeared to me to be consistent with blood. The problem is that it was not confirmed. I'm going to direct counsel to move on from that.
Take that, prosecution.
All right, let's have the jurors, please.
The impassioned argument of Barry
The
prevailed.
defense that Mr. Cochran indicates he'd like to interpose an objection to. Let me indicate to the court that what it is a synthesis of evidence that has been admitted already.
A
All right, may I see
synthesis
it?
of evidence. A synthesis of evidence that has been presented. Not evidence has been presented. We almost got it done on Sutherland sighting. What does a synthesis of evidence mean? He's toying with us. He's toying with us now.
Okay, what does he look like? He's OJ Simpson. I think you know his record. Did you just Simpson? Be over here. Okay, what is he doing there? He's told us again. Show me over. Wait a minute, what kind of car is he in? He's in a white Bronco. First of all, he broke the back door down to get in. Wait a minute, what's your name? Nicole Simpson. Okay, is he the sportscaster or whatever? Yeah. Okay, wait a minute, we're telling police. What is he doing? Is he threatening you? He's fucking going nuts. Has he threatened you in any way, or is he just harassing you? You're going to hear him in a minute. He's about to come in.
Second segment. That's the end, Your Honor.
Who is he trying to high five back
What
there?
is the connection between the audio and the montage?
Good question, Judge.
Is that the audio that you anticipate playing at the same time as the montage?
Yes. It goes in tandem with the argument that's going to be made to present it,
Uh-oh.
which is the motive.
Uh-oh, Johnny Cochran is standing up now. Marcia's about to get her lunch fed to her, I think.
For the murder.
Do you think the tape directly relates?
Yeah, see, this is the thing. They want to play a tape from years before of, apparently, allegedly OJ trying to get into her house, where the dispatcher asked twice, has he threatened you? And she did not say yes. And somehow that's supposed to prove that he murdered her on, this particular night where she was murdered. And then they want to show a montage of pictures surrounding this. That seems kind of shady to me.
To the last two photographs?
I'm sorry?
Does the audio tape directly pertain to the last two?
I'm sorry, the
last two photographs.
yes, that's the point. That's the case, Your Honor. That's the whole, that is it. That the motive for these murders
Okay.
is the nature of the problem, and that's why she wound
The
up
motive for the murder is the
Well, it's a
nature
worse-
of the problem. The motive for the murder is the nature of the problem. That's word salad.
Synthesizing the
Sorry,
evidence.
word salad.
We do it through verbal arguments, saying we have the motive, it carries forward and up till the date of June the 12th, and then we do it with pictures that have been admitted in evidence. All of us has been admitted.
Mr. Cochran?
Nobody likes her, Tammy.
This is unfair.
Oh my God, I love Johnny Cochran. Rest in peace. Oh, my brother of another color. Oh my Lord. She does this big ranting and raving and ranting and ranting, and he just ends up, this is unfair. I love you, Johnny. Oh my Lord. You are a damn. See, this is what is great. The defense had people put in their jobs so well. Let Barry Scheck handle the scientific information because he's got that steel trap mind. when you need to aggressively just literally murder someone on the stand, you get F. Lee Bailey there to rip them apart. When you need a good orator, when you need to have a good preacher on the stand, when you need to have a come to Jesus meeting with the judge and the jury, you put on Johnny Cochran. Put on brother Johnny Cochran. Oh, the defense was so well defined in their roles. Each one of them is a master at their particular part of the trial. This is unfair. What? From that point, she's just crushed.
It's incredibly inflammatory. Those tapes have nothing to do with the photographs that are up there. If she wants to argue that, then so be it. This is improper rebuttal, Your Honor. They try to spring this on us at the last minute. The tape that she's referring to, it's a different time than the photographs. It's a photograph from 1989, tapes from 93, and the pictures, they try to link all these things together. They have nothing to do with this evidence.
Right.
This
Preach,
evidence
Johnny.
of other offenses was limited for a very limited purpose, so the court is aware of that. The reason it was in there, and this would be incredibly unfair and is typical of what the prosecution is doing in this rebuttal. This is outrageous, Your Honor. They're vouching, they're doing all of these things, taking things out of it where they know they're wrong, yet they're trying to do this. At the 11th hour, when she has maybe an hour or so left, we're faced with this. This is outrageous, Your Honor, and you should stop it. They held this back.
An hour and 43 minutes
keep us
left.
from dealing with this until the last minute. Now we see it at 1:55 on the last day of her argument. This is outrageous, Your Honor. The court should put a stop to it. This is the end of it, and we should get on and get this case to the jury. They're never going to stop unless you exercise your wisdom and discretion and stop it.
Thank you.
Beautifully put.
Your Honor, I don't think that Mr. Cochran has the right to use the word outrageous. This is the
Oh, shut up, Marcia. That is not a legal argument. That's just a petty, spiteful, bitchy thing to say. That right there shows that she has lost this argument already. He doesn't have the right to use the word outrageous. That's petty sniping. That means you have nothing else better or more legally proper to say. So you go in for the snipey attacks. Bad move, Marcia.
man who argued Mark Furman was commensurate with Adolf Hitler. This is the man.
He kind of was. He kind of was. He was a genocidal freak who kind of hated everybody. He kind of was.
Man who demanded jury nullification. But this is proper argument.
Let's address the issue.
Yes.
Exactly. See, there's the judge going, Marcia, you ain't talking about the merits of the argument.
Are these items in evidence?
They're all in evidence, Your Honor. And the purpose for which we're using the tape being played over these photographs is the very purpose for which the
Jules, take a
domestic
rest.
violence matters were admitted,
Take
which
a
is
rest,
for the
Jules.
purpose of motive and identification. And that's why it's been synthesized this way. I think we're using it to an entirely appropriate purpose, as the court has permitted us to do, with the jury instruction that limits it. We have, I think, appropriately argued it. Mr. Darden has appropriately argued in that vein. But this is argument, and we are synthesizing all of it.
Yeah, but
the domestic
it's not-
violence is the underlying theme in the case. It is certainly the motivation in the case, and it goes to identification as well.
All right, I think the record is not completely clear because we did not identify what all these items are. But what we started out with
Love you,
were
Jules. You're funny.
photographs of the domestic violence injuries, the Polaroid photographs.
Yes, Your Honor, I should be more specific. They are the domestic violence photographs with respect to the 1989 incident. Then I believe they are the photographs from the safe deposit.
Look at Judge Ito, 1995, rocking the Casio digital calculator watch. That is a fly judge right there. He's rocking the Casio digital calculator watch. Sweet.
Box. And then we have the photographs from Rockingham that pertain to this case, and they conclude with the photographs of Bundy pertaining to this case.
And this is while you're playing the first portion of People's Exhibit what?
What is the number?
This is the 93 tape.
It is both the 89 and the 93 tapes.
Your Honor, may I say something when you get an opportunity?
Ms. Clark, you concluded with your argument?
Yes, Your Honor.
Your Honor, in the 93 incident, as you're well aware, the tape they played, there was only the French doors were damaged. There was no physical anything. In the 89 incident, they ran these two things together. They have nothing to do. They're juxtaposing. This is an interpretation they're placing on the evidence. If they want to show the evidence, that's
Show
one
the
thing.
evidence.
But to play the tape in conjunction with that, that's a production from the district attorney's office at this 11th hour, and it's unfair. It's absolutely unfair. It's inflammatory. This is improper rebuttal. We've seen all this evidence in addition to that. The court has told us on several occasions, you're going to stop us when there's redundancy. And this is absolutely redundant. It is improper. The prejudice far outweighs any probative value because they're meshing things that don't follow. They do not follow. This evidence was limited for a limited purpose. And they're tying things together and making a conclusion, just as she did with this incident regarding the air conditioning. And that's unfair. Vouching for things, it's wrong, Judge, and it shouldn't happen.
Is that the word for the day?
Vouch. Yep.
Vouching?
Yes.
Vouching is the word for the day, Your Honor.
Yes.
The I word, and it's personally vouching, and it's wrong, and they know
Preach.
it's wrong, and everybody knows it's wrong, and it shouldn't happen, Judge.
Preach.
Ms. Clark,
Preach, Brother
I do
Johnny.
think it is a problem with the soundtrack because you've run the two soundtracks together, the
9.
89. Is this two tapes?
Yes.
Both of which have been admitted.
I
Why is that?
understand. It's misleading because you can't tell that they're two tapes. There's no break with them.
Well, I'll
Yep.
tell them.
Sorry.
How about if I tell the jury we're
No. You can't say, oh, here's one tape from 1989. Oh, and now here's another tape from a different year. Oh, and by the way, here's some pictures from like 10 years later. No, you can't. Well, not 10 years later, a few years later. No. You don't get to make a movie. You don't get to make an edited movie and then tell them about the different parts. No, that's
running
unfair.
them together
When do you anticipate doing this in your argument?
at the end? I'll introduce it. I'll explain to the jury.
No,
We've run the two tapes
no.
together, and I have to. I have
No,
to
you
tell them
don't.
what they're seeing.
You don't have
and
to.
hearing. I don't want to mislead them. I want to tell them the truth. I want
You're misleading them by putting together a production of two different calls from different years, for God's sake, and then putting together a montage of pictures from yet a bunch of other different years. That is by definition misleading them, Marcia Clark.
I want them to know exactly. I want them to hear exactly what it is that they're hearing. I want them to know that's the 89 tape, and then we're going to run the 93 tape, and we're going to run the pictures from 89. We're going to run the pictures from the safe deposit box. I want them to be very clear about what they're seeing and hearing. I don't want there to be any mistake about it.
Then why did you put it together in a montage?
With that caveat, the objection's overruled.
Oh,
Let's proceed. Sound the
No,
jury, please.
no, bad
Rejoined by all the
eater,
members of our jury panel. Good
Bad
afternoon again,
eater.
ladies and gentlemen.
bad, mean, nutty,
And
evil,
Ms. Clark,
wicked.
you may
Edo.
continue with your concluding summation.
Thank you very much, Your Honor. Good afternoon, ladies and gentlemen. I forget where I left off, so I'm just going to pick up with something else. No,
you didn't forget where you were going, so you're going to pick up with something else. No, you didn't. The judge told you had this big long argument about the alleged blood on the air conditioner, and the judge told you to move on. You didn't forget where you are, so you're going to change subject. No, that's not how that works at all. See, there she goes again, misleading the jury with the very first sentence out of her mouth, right after saying the last thing she wants to do is mislead the jury. I do not like this woman, Sam I am. I just don't. Urgh.
there were some remarks made about the treatment given to some of the witnesses. And I confess that there are probably some I could have been nicer to. Mark Partridge came in to testify to the defendant's demeanor when he came back from Chicago. And this kind of it's a really good example of what I'm talking about. He made notes, detailed notes the next day, you might remember, of everything that the defendant said to him and everything that he said to Mr. Simpson. And he copyrighted them. He copyrighted them. What does that mean? That means you have a proprietary interest in the material. The very next day after he speaks to him, he's going to sell these notes. He's going to make some money off of this.
What?
He's got some proprietary interest in this. Now, what kind of a man is that? What kind of a person is that? And it's very indicative. It's very, very consistent. You heard from Ellen Aronson. She came up to testify. She was the one, she said, she called into the police to say she initially said that she heard the dogs barking at 11:30. Then she saw the preliminary hearing and she realized, I better call back again and change the time so I can make myself a witness. You know, a groupie. And yeah, I don't like that kind of person. That doesn't belong in a criminal trial. That's the kind of person that's going to...
Sustain. Counsel, rephrase that, please.
Okay. That's the kind of person that will offer any testimony they can to get their 15 minutes of fame.
Oh, Amber Heard
That's not the kind
trial.
of
Here we
testimony
go.
You can trust. At the end of the trial, or at the end of the people's case, we had or maybe it was the whole trial, the judge took judicial notice of something. And I'm sure you were wondering, what did that relate to? And the judicial notice that he took was that the moon on the night of June the 12th was a crescent moon, 12% illuminated. You may recall that. That's very important for two reasons. First and most important reason is it tells you what the lighting conditions were like that night. It was not a full moon. It was a dark night. Witnesses, their testimony has been referred to by Mr. Darden, have confirmed that it was dark. Officer Risky made it very clear it was dark. Sukru Bostepi, who was walking with the dog, who said, I would not have looked up there. I wouldn't have seen the body if the dog had not stopped and looked up the pathway. That's important.
Just Don,
so
there's a difference between long.
That means it's an undisputed fact you are to accept a 12% crescent moon. When I cross-examined Ms. Aronson and I asked her what was the moon like, oh, it was a full moon. Are you sure? Yes, I'm very sure. It's in the record. Have it read back. She was very sure. She was very wrong too. She also testified that she was very sure that she called the police officer to give her statement to him the first time on June the 14th. I showed her the police report. It said June the 15th. Are you sure? I'm very sure. She's very sure about a lot of things, but one thing she really didn't know was when she was walking down that street. And you know how else you know that she wasn't down that street when she said she was? Because Mark Storfer said he looked out his window at 10:23. I read it and I reviewed it, and now I'm so tired I can't remember it exactly. You can have it read back because I think that what he said was 10:23.
Counsel.
In any case,
There's some objection. Please stop.
I'm sorry, I didn't hear.
Because
All
you're
Remember, you're the judge of the facts. You're the sole judge of the facts. Thank you, counsel. Proceed.
Yeah, and you know, if you have a doubt about something I'm saying, please have it read back to you or look at your notes, okay?
no, how about you don't say shitty stuff? I mean, you mean crappy stuff like that.
But it was within 2 minutes of when she passed Bundy that he looked out his window. If she's walking down Bundy and that lights colored outfit that she said she was wearing on that night, he should have seen her when he looked north on Bundy, because he said he looked out the window, looked north, and he saw no one walking there, which is actually consistent with the other witnesses who don't say that they saw anybody either. All of the witnesses that were called by the defense somehow were in the same place, but none of them saw each other. It's very weird.
You're weird. No, you're weird. We've only got like 15 more minutes to have a good Donald Sutherland sighting. Hi, Strawberry. What's up, baby? What's up, little girl? How you
Defense
doing?
has raised the issue about there being, why wasn't there dirt? Why wasn't there mud at Rockingham tracked in the house on that light carpet? There wouldn't be.
There's mud.
There was. Into the mud. You saw the bloody shoe prints, and they faded out halfway down the Bundy walk, to the point where there were no visible bloody shoe prints on that walk at the end of the walkway. Then you saw the imprint in the Bronco, so that whatever blood was left on the shoe was picked up by the soft tufts of the carpet. By the time he gets back to Rockingham, there isn't much left there. Whatever blood, whatever mud, whatever dirt he's got on his shoes, he's tracked off. This is common experience, you know. Your blood or mud, whatever you get on your shoes doesn't stay there forever. You walk, it comes off, and as you walk, more comes off. By the time he gets home, there's not a lot of excess there. Maybe there's some trace amount, but you're not going to notice that on a carpet. And so that in itself says nothing. And the testimony of their experts, Mr. McDonnell, I think even Dr. Lee, does not dispute that. Of greater importance,
Overruled.
of greater importance, I think actually, yes, Dr. Lee even testified. He was asked specifically, if somebody walked through dirt, walked through berries, would you necessarily see it? And his
Walk through
answer
Barry
was,
Shack.
you might see it and you might not. The absence of evidence is not evidence of absence. And that's what their witnesses have said.
The absence of evidence is not evidence of absence. You should send that into Reader's Digest. They have pages for people like you. Deep thoughts.
Now, there was an issue raised with respect to EAP. That's a conventional blood marker, okay? And you may recall there was testimony that Nicole Brown had an EAP type of BA. The blood under her fingernails was typed and came back with an EAP of B. We had testimony from Greg Matheson to indicate to you that that was degraded, that the BA degraded to a B. In order to confirm that it was her blood and not the blood of someone else, they did DNA testing on that blood. And the DNA confirmed that it was hers. It was her blood, and that it had degraded. And it had degraded because, number one, the EAP marker degrades very rapidly. Number two, her hand was in wet blood, and blood in a wet state degrades quickly, more quickly than it would on a dried gate, for example, or in a dried condition. Now, there's more to that.
Marcia.
You are not a nice person.
First of all, Gary Sims agreed with Greg Matheson in his conclusion that the blood under her fingernails was hers and not that of another perpetrator. But
Excuse me, counsel. You need not make that objection any further. I've instructed the jury that they are the sole judges of what the facts are in this
But
case.
she keeps saying
If
it.
counsel chooses to argue a line of argument that is in contradiction to what these jurors find to be the facts, they do so at their own peril. The objection is made. Thank you. Ms. Clark.
thank you. Moreover, Dr. Lee, who was called by the defense to testify, never contradicted that. And he agreed that Greg Matheson was a good scientist. There was some testimony, I think, from Dr. Bodden that you can get somehow the blood of someone under your nails without getting the skin under your nails. I don't see how that can possibly happen. But what is interesting...
Overruled, counsel.
What is interesting is that the defendant's EAP type is also a BA. Also. Now, the blood on the rear gate, that blood that came back to the RFLP testing, making the defendant 1 in 57 billion or something, obviously it's an identification. That's his blood. There's not even any dispute about that. That's his blood on the rear gate. That blood also had an EAP that was a BA degraded to a B. That blood also...
Hold on. Counsel, with the court reporter, please. All right. Thank you, counsel. Ms. Maxim, are you ready? Proceed.
Thank you. I'm going to finish today, ladies and gentlemen. I
No,
promise.
you're not. You're going to finish
I
next week
promise.
for us.
Okay. I really, but
Hey,
it's so
positive life
important. I
force
really
one.
want the record to be straight. I want you to know. This on the rear gate 117, okay? There was testimony to indicate that Mr. Simpson's EAP marker was a BA. So was Nicole's, a BA. There was testimony in the record indicating that a BA can degrade and turn into a B because the A bands drop off. That was early testimony. That's what happens. It can degrade that way. That was the testimony. The blood under her nails that had the DNA that typed back to her also had an EAP result of B, which Greg Matheson testified was indicative to him that the EAP marker had degraded, that the A bands had dropped off. That was his testimony. With respect to the rear gate, he testified as well. That's the rear gate where the defendant's blood is. DNA came back to him. The EAP marker that he has a BA just like hers became back degraded to a B. And here's the testimony that he gave. He stated as follows. And was 117 identified as being one of the rear gate stains from the Bundy location? Answer, yes, I believe it was. And you got a B-like pattern on that? Answer, I called it a B question mark inconclusive, yes.
Proceed.
I just read it to you. If you want to have it read to you, ladies and gentlemen.
I've ruled. Proceed.
The page number is 25,965 if you want to read it again. What that indicates to you, ladies and gentlemen,
They're pissed.
is
They
that
should be.
there was also testimony, I should
They're
tell you.
righteously pissed.
There's another conventional marker for serology called PGM. Maybe you remember that. And the PGM on the rear gate was also degraded. There was testimony, I believe, from Greg Matheson about that as well. That's important for a couple of reasons. Number one, with respect to the blood under her nails, what it indicates is that it's her blood. It's her blood. Number two, what it also indicates is that the blood on the rear gate was degraded. There was PGM degradation and EAP degradation, which indicates to you that it was out there for a while. It's all in the record. Very logical, and it's very consistent. I could go into greater depth on this and talk about, what they're trying to tell you, ladies and gentlemen, is that a very, very sensitive, what they call exquisitely sensitive test in the PCR picked up Nicole, but not the blood not the blood of the real killer that was under her nails. Well, how could that be? Conventional serology is not nearly as sensitive as PCR, not nearly. So the EAP marker that Greg Matheson testified was breaking down under her nails, that isn't nearly as sensitive. They want to point you to that and say that's the blood of the real
It would be an
killer,
ongoing
in
objection.
contradiction to the testimony of Greg Matheson and Gary Sims. And yet we have very sensitive DNA testing that says it's hers, and they say ignore that. It doesn't make any sense. The blood under her nails is hers.
Everything that guy just
That's what makes
says
sense.
bullshit.
That's logical.
Thank you.
There was also testimony, and there was also some points made about bindle number 47, the infamous bindle number 47. That's one of the Bundy blood trail drops. And in that, Dr. Lee testified, I believe, that there was the bindles that were placed into, the swatches that were placed in the bindle were obviously still wet when placed in there. And some of the sizes and shapes of the swatches matched the imprints of blood on the bindle, and one did not. And a big deal was made about this. I'm not really sure why, because it's inconsistent. Remember I told you I'd point out inconsistent defenses? Their defense seemed to have been all along that the Bundy Walk blood drops that all came back to the defendant were contaminated, right? Well, with this testimony from Dr. Lee, it would seem they're trying to say that there was some kind of planting going on.
Bindle is Steve Irwin's
imprints
daughter.
in the bindle didn't match.
Bindle Irwin.
I don't know which one they want to
Australians
choose,
here in chat.
but the truth of the matter is that Colin Yamauchi said he took one of those little swatches out for testing. So of course, there's going to be one imprint there that doesn't match the swatches because one of them's gone. He tested it. There's no big mystery here. It's very simple. It's very, very, very simple. And it's interesting that they really did not tell what they don't make a big deal about, which I don't understand, and was testified to, is that item number 42. Item number 42 is Nicole's blood pool. Remember, I told you that they took a representative sample of the blood underneath Nicole and the blood that was right near Ron Goldman and the tree stump. Okay, his was number 41, hers was number 42. Number 42 then was her blood. And in that one also they have imprints. There was one imprint, I think, that there was testimony that didn't match the size of the swatch. What, they're planting Nicole's blood? That would be the logical inference to be drawn in her own blood pool. That would be ridiculous. But you see what I mean? That exposes the fact that all of these arguments about the minutia make no sense when you look at the big picture.
It's a joke.
You look at the big picture and you realize, well, there's nothing sinister here. Open the doors, open the windows, let in the light here, blow out that smoke. Because when you look at the whole picture, you see the truth. It's very, very simple.
But I'm not done. I'm still going to go for another hour. I'm just pausing.
All right, I'd like to talk to you a little bit about contamination. There was a lot talked to you about that during this trial, I know. And it really is not as complicated, and it really is not as easy to do as they've been making you think. And I'd like to show.
It's not as complicated and not as easy as they, what? Marcia, do you realize that sentence? Like, you've contradicted yourself within the same sentence? Marcia.
How dare you?
Show you what I mean by that with a few slides. I'm going to try not to say things like substrate control and reagent blanks and all that stuff. I'd like to talk about it the way I talk about other things, everything else in my life except for
My
the
shit
science
husband
stuff.
that I'm divorcing. Oh, wait, what?
I don't believe you.
All right. Here are the reasons why you can have faith and you can rely on the validity of the results of the testing of the Bundy blood trail. Number one, you've heard us talk about it too many times. The substrate controls were clean.
You just said you weren't going to say
They
that.
should have showed contamination, and they didn't. And they were tested, and they came up clean. And what that gives you is quality assurance. You know you can rely on the result because you have this. The bindles were closed. That's very important. Remember, if you will, the testimony concerning opening of the blood vial, the defendant's reference vial. And they were saying that when the blood vial was opened, that somehow contaminated the bindles and the swatches that were taken from the Bundy walk, that there was some aerosol effect and his blood was spraying all over the place. Well, the problem with that is that Collins' testimony was when he opened the blood vial of the defendant's reference blood, he was 10 to 15 feet away from the swatches, and these swatches were in closed bindles, and not only that, but the bindles were inside envelopes that were closed. Now, what testimony have you heard in this trial that DNA can fly from a test tube into a closed envelope through a closed bindle onto the swatches? None. In fact, there's testimony to the contrary. And that brings us to next. There was.
Oh my Lord. We have an hour and 20 minutes left. We watched an hour and 25 minutes. We got an hour and 20 left. This is where I'm going to throw in the towel today. We suffered through our 2 hours. Oh my gosh. That was just torturous. Let me get rid of Joel and the bots here. Hang on. Go away, Joel and the bots. Where's my Joel and the bots thing? There it is. Boop. Go away. Wow. Are you all just captivated and massively engaged by her thrilling closing arguments in the most important case in her entire life? No, you're not. This is just bad. This is just bad closing. But I promise you, it ends next week. The suffering ends next week. She will shut the F up. We will have a verdict. I wonder what it is. Will the jury find him guilty again? I mean, not guilty again? Stay tuned for next week's final episode of OJ Simpson. I'm sorry. I've got to inflict Marcia Clark on you just one more time. One more time. But then we're going to move on to the state of Florida versus Donald Wayne Hartung, who has been accused of a witchcraft ritual murder of his mother and two younger siblings. And by younger, I did mean like he was 63 and his two younger siblings were 47 and 49. We'll do that trial. That is a very, very fascinating trial. It's kind of a legendary trial that took place during COVID times. Not much was known about it, but interesting case. So that's what we're going to start 2 weeks from today. And we had up to like 160 people here, far and away the most people we've ever had for our chill OJ Simpson stream. Since we started doing this 63 episodes ago. And that stretches back over a about a year and a half period. Well, it should be Warlock Craft Daily Quick Bites, but they're calling it the Witchcraft Murder. You'll just have to stay tuned and find out why. And we'll be covering that trial from just gavel to gavel because it was about a 3-week trial. And, it'll take us about another 6 months to a year to get through, but we'll do it. Because, hey, what else are we going to do on Thursdays? We just hang out and talk. This is our chill stream of the week. So that's what we did today. Tomorrow, as I've mentioned several times, is F It Friday, where we just say F it. We don't care what we talk about. We have no set topic. We have a great panel of guests on who talk about anything they want to talk about. Arguments happen. Lots of friendly banter happens. Disagreements happen. Agreements happen. It's a fun-filled time where we just have it's a constantly rotating deal. We've got some guests locked in. There are other guests that just need to be on standby. So if someone doesn't show, or when it starts to slow down a little bit, we bring more people on as the time zones change and whatnot. So we keep this going as long as until one of two things happen. One, my liver gives out due to alcohol consumption, or the chat just decides they've had enough and they stop giving super chats, because it is a boozy griftathon. The entire purpose is to grift as much money as possible from all of you fine, wonderful people. Why? Just because we do it one day of the month in full knowledge that it is just a griftathon. You throw all your money at me, so we don't have to beg for money the rest of the month. But we also have a good time. Every $100 in super chats that comes in, I do a shot of whiskey. And because it's St. Patrick's Day weekend, we'll be doing shots of Bushmills 10-year and Redbreast 12-year Irish whiskey, because St. Patrick's Day. And also, it's the 69,000 subscriber celebration. It's the 69,000 celebration, even though we're already up to 72,000. But it's still going to be a 69 party. It's going to be a great big 69 grifty boozathon St. Patrick's Day party. So bring all your money and throw it at my feet and enjoy me and the panel of guests who will be, where's my panel of guests list? So far, the locked in panel of guests who are most likely to show up are Danny on Direct, Steph the Alter Nerd, potentially criminal Sean, influencer Laura De Laguna, Anna, that Star Wars girl, Nicholas Starro, comedian Lila Hart, Ian Runkle from Runkle of the Bailey, Flux, our very own Flux from House of Flux, Hayden from Aussie Overlord, Surly Durley, a.k.a. Jess, a.k.a. Moxie Dame, Lady Law 5791, who is seriously low-key one of the funniest people you will ever meet in your life. She doesn't say much, but when she does, her wit is scathing. She is a true gem. Talk with Sally. Talk with Sally is one of the greatest people out there. She is an F It Friday legend. And MG Law will be there as well. And there's a bunch of other people that watch that should just always be on standby. So, there we go. Those are the locked in guests. Other guests will be coming and going. Don't miss it. Bring all your super chat money for that day. And remember, the secret is if you slowly do it, so there's like one drink every half hour or 45 minutes. I don't get drunk. You got to front load everything. Get everything right up front, because as the $100 marks come in, that's when I take the drink. So if you front load a bunch, then it gets crazy real quick. That's the strategy. That's the F It Friday strategy, but it is so fun. We're going to have a great time this Friday for the St. Patrick's Day 69 party, the Boozy Griftathon. Don't miss it. It's going to be fun. That's all I'm going to say about that. Let's see how our poll turned out, should we? Let's look at our poll, and then we'll shut this baby down. OJ is back, baby. 9% of you said, yes, give me that sweet Marcia Clark. 24% of you said, yay. 26% of you said, I'll miss Donald Sutherland. And I'm going to miss Donald Sutherland too. I shouldn't have closed the window. Dang it. I was going to go back in time and just get our closest approximation of Donald Sutherland. But this was a week of no Donald Sutherland. We might have to do it twice next week if the opportunity arises. And 41% of you said sarcastically, yay. That's our like and subscribe poll. All right, everybody, let me see where we're going to send you here. Let's see if somebody is doing something. Who is doing something right now? That's the question. Who is streaming now that I think you might find interesting? Let's see. Content. Live. OJ, that's us. Customization. Redirect. Redirect to. Wow, what's the deal? Not many. Not a lot going on. Let's throw you out into the wild. Everyone, go where you want to go. Be who you want to be. Chase who you want to chase. I will see you Friday evening. There'll be no stream 24 hours from now. It'll be Friday evening U.S. time, starting at 8 p.m. Not 9 like it says on Twitter or or actually on the live stream thing. It will be starting at 8 p.m. Eastern time. Don't miss it. It will be there. So, all right, everybody, let's go. Oh, see, I can't forward to Critical Drinker or Alita. I don't think I can. I don't think I can forward to Critical Drinker because it didn't show up in the available slots. Because that would be awesome to send you over to him. He's a handsome man. You want to watch someone fangirl. Get Flux near Critical Drinker. Flux was Twitter pated when they met. Let's see here. Let's see. Critical Drinker. Yeah, nope. I don't have the authority to redirect to Critical Drinker. So there you go. All right, everybody. I'm going to shut this down. So take care of yourselves. And we will see you Friday evening, U.S. time, for the March St. Patrick's Day Effort Friday 69 Super Boozy Griftathon. Until then, Lorax, me saying I love you guys, mods. Thank you for everything you do. Thank you, chat, for the support you give. And thank you for just being here, particularly on a very, very slow, very, very chill OJ Simpson Thursday. So until tomorrow, you guys be the best you that you can possibly be. See you later.